three myths that prevail in the minds of married partners who are undergoing a divorce procedure or who have just divorced or who are intending to divorce. The first myth, and I'm talking about the law of co-ownership with specific view to family law and the law of property. The relevant law is the law of England and Wales. The first myth is that married partners, married couples, tend to think that because they both appear on the title deeds and they are registered as joint legal proprietors of the house, they do own the house together. Well, basically, that's a myth. The fact that they appear on the title deeds together and are registered together as legal proprietors means that there is a strong presumption that in equity they have both an interest in the house, and not only that, that they also hold the equitable interest equally, which means on a 50-50% basis. To start with, there is a presumption that they hold that they have, each of them has an ownership in the house. This is a presumption, meaning that given the right circumstances, given the right context, as in the very famous landmark case of Stack versus Dowden, it was said that context means everything. If there is evidence, I mean, the party that claims to be the sole beneficial owner of the house, regardless of the fact that both names of the partners appear in the title deeds and they are registered as joint legal proprietors, might be able to prove that the reason both the names appear in the title deeds was simply for administrative reasons. It was simply to make him, either the wife or the husband, simply to make them appear as a unity and make it more viable for the real owner to purchase the house in the first place. For example, this happened in Abbey National versus Stringer. So it's basically when there are reasons that are proved by the party who claims to be the sole owner of the house, and they are strong enough to rebut the presumption that both parties have acquired a share in the house by virtue of being joint legal proprietors in the house. Nevertheless, the importance of the joint proprietorship is not to be underestimated, and the presumption that comes along with it, because as was said in Barron versus Fowler, the presumption it's really heavy, and it's hard to detract from that presumption. It's a hard task to do that. The presumption just stands firm there, and it needs to be contested and needs to be rebutted upon the finding of very exceptional circumstances. For example, a non-traditional couple that basically has its finances separately, etc., etc. But we're going to go to that. So it is hard to rebut the presumption, but it's still a myth. It can be rebutted. Could be a reason. I mean, anything can happen, especially when the couple is not a traditional average and a traditional average middle class family, but it is basically a couple that has many properties and not really strictly a traditional one, but it was also something more of a commercial enterprise. I mean, these things happen, especially in the 21st century. So it could be that, as regards a specific property, that one of the parties just wanted to make himself more financially viable, so they both, for administrative reasons, appear on the title deeds and they register as legal proprietor just to make it easier for them to acquire a mortgage on the house for some reason, so that the bank basically holds another party accountable as a joint mortgagee who has an interest in the house, of course. Second myth is the fact that they own the property on a 50-50% basis. They own the property equally. Again, that's a myth. That's a myth because, as I explained before, I was referring to the acquisition part. I was referring to the fact that if they appear on the title deeds together, joint legal proprietors. Now, secondly, not only they are presumed to have the interest, but they presume to hold the that interest in equity equally, which means their equitable interest is on a 50-50% basis. This again may be rebutted, as was shown in Stack versus Dowden. However, the case again of Byron versus Fowler is there to remind us that it's pretty hard for the presumption to be rebutted. If there is no, for example, reason, if there is no reason proved that the parties were simply put together on the title deeds and were registered as joint legal proprietors, just to make it easier for one of the partners who is supposedly the real owner, to make it easier for him to acquire that property. If there is no reason, then the court will proceed to the quantification stage. There, it's going to find it's going to take either resulting trust approach, which is basically becoming more and more redundant in the family context, or either on a broad brush constructive trust approach, as was taken in Stack versus Dowden. If it takes a resulting trust approach, which is highly unlikely to happen in a family context, I mean, what basically may happen is that it will it will assess the extent of the shares of the property of each partner according to a constructive trust approach, because resulting trust to basically occur more in a commercial setting. Um, so, if there is a constructive trust approach with regards to quantification, yes, one of the parties might be awarded a larger share than a 50% share, and it may, in very exceptional circumstances, it may also be tantamount to the total equity of the house, meaning that whereas the other party was presumed to have an interest in the house, on the quantification stage, since his interest is has dwindled, has been reduced to a very disgraceful, a very minuscule rate, that he might be considered not to have an interest in the house at all if his interest is actually 0%. And this tends to happen in again in exceptional under exceptional circumstances, where the both the parties, let's say, they were not basically having a pool of assets together, they were not mixing the finances, they were holding separate bank accounts. There was evidence of their discussions, of their agreements, that they were holding back some of their finances and not basically playing with open cards that much. For example, in the case of Barron versus Fowler, which was more of a case, a family context case, a traditional family where both parties were taking care of the contributions with regards to the family and to the property. Contributions, not necessarily, they don't necessarily need to be financial. For example, the father, the man was paying for the council tax, was he had paid for a substantial amount to the acquisition of the property, and he had also contributed towards the mortgage installments of the house. However, the wife was contributing by paying for extra fees of regards to the school of the kids, with regards to school trips, and she was also making it possible for the husband to keep on basically bringing the bread to the house and working, since she was taking care of the household responsibilities. So apart from that, there were also other in the context, because as I said, context is everything. even though the wife was not contributing financially, um, she was held to be contributing towards the property, because there were no express agreements with regards to who was going to be paying for what. They were both contributing. They were both basically taking care of the responsibilities of the house. They both had executed mutual wills. Third myth. The third myth is that there is a joint ownership of the house. That when there is a financial contribution by one partner, when there are financial contributions towards the acquisition of the price of the house, towards the mortgage installments, towards the council tax, towards utilities, towards tax in general, and other kind of outgoings that may occur. This person can claim a larger share on the basis of a resulting trust, or he can claim a larger share on the basis of a contractual trust approach. This is again a myth. The person who does not contribute financially, for example, let's say if the wife does not contribute financially, can again be considered to be contributing if, in the absence of certain circumstances, for example, in the absence of agreements to who is going to be paying for what, in the if there is a pool of assets, if they don't hold their assets separately, if they don't own many properties, if they both help and make it possible for one party actually to pay the mortgage installments, even though the other one is not contributing a single, let's say, dime to the house. Of course, with the blessings of the presumption, I mean, the presumption that they both hold the house in equal shares is it's quite a really hard one to deviate from, to detract from. It's going to be there unless exceptional circumstances are shown, which do not really point towards a traditional average middle class family, but point towards more of a family with strong commercial undertones into the marriage, such as was shown in the case of Stack versus Dowden. Well, I hope this video was helpful for people that are considering divorce, or people just that go through a divorce process. So thanks very much for watching the video.